Good morning and a really warm welcome to everyone. Thank you for taking time out this morning to join us for our live event, which is a mock arbitration. We are absolutely delighted to be joined this morning by two incredibly strong barristers, Christopher Wagstaff QC of 29 Bedford Row, who is a really seasoned arbitrator and an excellent skills in the courtroom too. And Laura Heaton, also of 29 Bedford Row, who is just superb, and she too has experience of arbitration. We also have an incredibly esteemed arbitrator, Nicholas Allen QC, who arguably is now heading to the top of the tree with the number of arbitrations under his belt. So for many of you, you may not have heard of arbitration, or you've heard of it and don't really know what it is. It's a form of alternative dispute resolution, which is another option for separating couples to consider as an alternative to the traditional court route. In family arbitration, the parties appoint an arbitrator who will make a decision that will almost certainly be final and binding between the parties. There are huge advantages. It is immensely flexible, almost certainly quicker. You get to choose the arbitrator for their expertise and their manner. You avoid the lottery of the court process. Some may say it's cheaper, although the costs are front-loaded, and it's certainly less acrimonious. So we've got our panel who are going to talk us through. And in terms of housekeeping, you can submit questions throughout the session via the Q&A function. Please submit questions, please put your name on. And we are, of course, recording this live event today. The scheme, the arbitration scheme, was launched for financial cases in 2012, and initially there was a flurry of arbitrators qualifying, but take-up has been slow and patchy, perhaps because we as family practitioners are somewhat resistant to change. In fact, it's probably taken a pandemic to get us to be paper light, so this is a new option in many ways for us, albeit that the scheme was launched in 2012 for financial cases and for children cases in 2018. So towards the end of I'm going to hand over shortly to Nick, but towards the end of the session, we will be looking for Q&A. So please do post your questions, and I hope that you really enjoy this entertaining gallop through, really, an arbitration and make the most of it and bear it in mind for your contacts and clients. Over to you, Nick.
Well, Ros, thank you very much indeed. Good morning, everybody, and thank you to everybody at Irwin Mitchell for inviting 29 Bedford Row along today to showcase arbitration and what arbitration can offer. As Ros has just said, we are going to run a mock arbitration this morning. What we're going to do is do it in two parts. We're going to have a mock pre-trial review first, in character, as it were, allowing me to try and keep two of my colleagues in line. Good luck with that. Mr. Wagstaff and Miss Heaton, as I will call them, and then we will come out of character and we will discuss how other issues that may arise in a pre-trial review, and then we will go back into character, do the final hearing, come out of character again, and I will do a short judgment, and then we will hand back to Ros, as she said, for the Q&A. Please do put questions in the Q&A, none too difficult, please, or if they are difficult, I'll make sure Ros asks them to Chris and Laura and not to me. Pre-trial reviews can take many forms. They can be on paper, they can be in a sort of in person, they can be done by the solicitors with conduct of the case, or they can be done by the barristers who are obviously instructed for the final arbitration, and we're going to adopt that structure this morning. So into character. Stern arbitrators, facial expression on, and I adopt the inimitable phrase and say, yes, Mr. Wagstaff.
Good morning, sir. This is, as you know, the pre-trial review in the matter of Laura Irwin Mitchell against Christopher, I beg her pardon, Mitchell Irwin against Christopher Mitchell Irwin. The final hearing is, as you know, listed for 3 days before you next month. Can I have the first slide, please? So you'll recall that in this case, the husband is 43, the wife is 41. They were married in 2004 and separated last year, and so have been married for 15 years. There are 2 children of the marriage, Giles 13 and Eve is 11. They are both intelligent children, and it is anticipated by both parties that they will proceed at least to university for tertiary education. So you'll recall from previous involvement in this case and from the notes that Miss Heaton and I have submitted,
I'm very grateful for those, Mr.
there is capital of around £3.7 million, sir, made up as follows. There is the matrimonial home has been valued by a single joint expert at £800,000. As I understand it, that is an agreed valuation. In fact, all of the valuations are agreed, and I'll let Miss Heaton correct me if that is wrong. There is a holiday property in Devon which is valued at £300,000. That, like the matrimonial home, is free of mortgage, and the single joint expert reporting on CGT issues instructs us that there would be minimal CGT to pay were that property to be realised. The husband, as you know, sir, is an equity partner at the large and well-known firm Beaver Prabani and Co. of accountants. He has an interest in that partnership, which has been valued at around £1.2 million. So there is also a related company that is wholly owned by the partners at Beaver Prabani, which has been valued at £400,000. That provides corporate services, accountancy and bookkeeping services and things of that nature. There is a pension fund in the husband's name, a SIP, with a cash equivalent value of around £400,000, and there is about £600,000 held in various bank accounts and stocks and shares and other realisable capital. So there is one issue in relation to capital, which is this: the husband says he purchased his equity share in the partnership with the assistance of a loan of £1 million that was provided by his father. Now, sir, what we say is that that is at best, from the husband's point of view, a very soft loan, and from the various things that the husband has said during the course of the marriage, we say it is in fact a gift. So that will be an issue for you to determine at trial.
Is Mrs. Mitchell Irwin calling her father to give evidence in relation to that, Mr. Wagstaff? Are you going to witness summons the father? How do you intend to deal with that?
Well, what we say, sir, is that the loan was made by the husband's father rather than the wife's father. I'm sorry if that was not clear. We say that the husband asserts a loan, it is for him to prove it. So if the husband calls his father to give evidence in relation to that, I will have a number of questions about a number of things that were said during the course of the marriage and in the hearing of the husband's father that rather suggests that this is anything but a hard loan, notwithstanding how one might characterise it as a soft loan or as a gift.
But forgive me, Mr. Wagstaff, do you intend to witness summons the husband's father if he is not called voluntarily by Miss Heaton?
I will give that some thought, sir. My present inclination is to say no, to that, and I understand that you'll be thinking about the time estimate, for the simple reason, sir, that we say that if the husband's father doesn't give evidence, that is a matter that you will take into account when assessing the husband's case. So I may wish to witness the husband's father, as presently instructed. I don't propose to do so. So, so far as income is concerned, if I can go on to the next slide, you'll see that the husband's overall earnings are in the order of £1 million net. That is structured in three ways. He has a basic income of around £400,000 a year net. He has around £200,000 in performance-related bonuses, and he has around another £400,000 net by reference to profit share. Those are averages drawn from the last 3 years. And again, as I understand it, those figures which were set out in the single joint experts report of the husband's business interest are agreed between the parties. So you will not be surprised to hear that after a relatively long marriage, the parties are agreed that the starting point is that this is broadly a 50-50 case, at least in capital terms. So one of the advantages of the arbitration system is, as you know, the parties are able to adjust the timetable by which matters such as open offers would normally fall to be done. So even though the final hearing is a few weeks away, the parties have already exchanged open offers, which enables you today, sir, to see the shape of the issue that is likely to be before you at trial. It's common ground, and again, Ms. Heaton will correct me if I'm wrong, that the wife will keep the matrimonial home and the husband will keep his various business interests and his pension. There is scope for discussion as to how the balancing payments will be structured, and it may well be that that is an issue that can be compromised, and if not, you'll have to decide it in due course. But sir, I think again it's common ground that the major issue at the final hearing will be the question of maintenance. You'll have seen from the offers and counter offers, sir, that the wife seeks a periodical payment, spousal periodical payments of £125,000 a year on a joint lives basis. She also seeks child periodical payments. It's agreed that you will have jurisdiction to deal with that, sir. Without going into the figures, the parties are not far apart on child maintenance. It's also agreed that the husband at this stage will pay school fees. There is an issue in relation to extras and in terms of whether they appear on the bill or not. And again, it may or may not be the case that that's capable of agreement. So far as spousal maintenance is concerned, the husband offers £75,000 a year, and he offers that for a term only, although he doesn't seek a section 28(1)(a) bar, and he says that the appropriate term is until the completion of both children's full-time education to tertiary level. So that those are likely to be the main issues at trial: the quantum of periodical payments and indeed the term. The husband says that the wife has a significant earning capacity. The wife says that she has not worked since outside the home, I should say. She has not worked since the eldest child was born, and so any earning capacity she does have is likely to be negligible.
Just pausing there, Mr. Wagstaff, if I may, just trying to identify what issues, if any, we will need expert evidence at the final hearing. From what you've said to me, you don't anticipate the need for expert evidence in relation to property or businesses. Given this issue in relation to Mrs. Mitchell-Irwin's earning capacity, I hear what you say on your client's behalf. Are you anticipating expert evidence on that issue, Mr. Wagstaff?
Well, so before the matter was referred to arbitration, there was an issue in relation to that in front of the recorder at the CFC who heard this matter, and his view was essentially that it was a matter for the parties. He declined to direct expert evidence, but said that he would be surprised if either party, having obtained expert evidence, that an application to exclude that evidence, an application to allow that evidence into evidence would be unsuccessful. So he essentially ducked the issue, sir. You'll be aware that there are competing views within the judiciary as to whether or not expert evidence is required, I suspect, sir, that in the context of this particular case, it won't be the most significant issue that you have to decide.
Do I take from that, Mr. Wagstaff, that sotto voce, you're not making an application for the admission of expert evidence on your client's earning capacity?
I am not, sir, and as I understand it, Miss Heaton is not making that application either. So it's to deal with expert evidence, since you've raised it, as I say, I don't understand there to be any dispute. There have been 3 single joint experts who have been involved with these proceedings thus far in relation, first of all, to the value of the 2 properties, secondly, in relation to the value of the husband's business interest, and thirdly, in relation to any capital gains tax liability that arises from the disposal of the parties' assets. As I understand it, the parties are in agreement with the conclusions reached by the single joint experts, and neither party invites you to call any of the experts to give evidence. Again, Miss Heaton will correct me if that's not correct. So one of the points, just before I depart from the facts, one of the points that you'll have noted, and this is more a question for final hearing than today, but is the makeup of the assets leaves the court and indeed you with the following conundrum. As I say, it's probable that the husband's overall award will include on his part the business interests that he has and his pension rights. So there will be a fair amount of illiquid capital on his part, and a great deal of the liquid capital on the wife's part is going to be required to rehouse her. So there is going to be precious little capital to enable a clean break settlement on a simple lump sum basis. So it does look increasingly like, sir, this will be a case for a spousal maintenance order of a significant sum. It's going to be no less than 75,000 a year for no less than 10 years. And the question is, what more than that is going to be appropriate? So it doesn't look as though this is one of those cases where an outright Duxbury sum at this stage is the answer to this case. The husband has a little borrowing, or has some borrowing capacity, but of course he's not likely to be able to rehouse mortgage free, and so that is going to make some inroads into his borrowing capacity in terms of putting a roof over his head. So far as I understand it, this case is essentially ready for trial. The issues are going to be whether the parties will be able to agree to narrow the gap yet further between them in terms of quantum of spousal periodical payments, and to deal with the matters concerning school fees and child maintenance. And so that will, of course, have a bearing on the time estimate of the final hearing.
That was going to be my final question, Mr. Wagstaff, before I probably will hear from Miss Heaton, if I may. So can you just help me with time estimate?
Well, sir, as things originally, this matter was set down for 5 days. When it became clear that neither party objected or took issue with the single joint experts' conclusions, it was reduced to 3 by consent and in consultation with your clerk, sir. And if the matter can be, if the scope of the dispute can be reduced further, then there is scope for further reducing the time estimate. As things stand, sir, with the issues before you as they are, 3 days is probably an accurate estimate in terms of allowing oral evidence from both parties, submissions, judgment, and so on and so forth, including of course, time for you to think about your judgment. So unless I can assist further, those are my submissions, and Miss Heaton, I'm sure, will correct me on any of the points that I may have strayed into error.
No, thank you, Mr. Wagstaff. Miss Heaton.
Thank you, sir. A very full set of submissions from Mr. Wagstaff, fairly setting out the issues that are between us. In terms of the points about capital, if we can go back to the first slide, please. The submissions made in relation to valuation, it is right, the parties are in agreement with the valuation reports. They have, or rather those instructing myself and Mr. Wagstaff, have made great efforts to put together the expert evidence in advance of any pre-trial review. They have done that by agreement in terms of identities and dealing with the experts on a joint basis, and there is no issue with those reports being relied upon. My client doesn't seek to call any of those witnesses. I think it is right to note that he would raise the question about the effects of the pandemic on the property values, but that's, sir, we envisage being dealt with by a joint letter to the property valuers to raise that question and for that to be incorporated in the report that you will have before you for the final hearing.
That reminds me, Ms. Heaton, thank you for prompting that. When I read the experts' report, and particularly the RICS surveyor's report, I couldn't see whether there was the material uncertainty clause that, as you and Mr. Wagstaff will know, many valuers have been putting in during the pandemic. So could I ask your respective solicitors in that letter which you've outlined to ask the RICS valuer whether or not there ought to have been a material uncertainty clause in his report, please?
Yes, we'll certainly make sure that's raised, sir. Thank you. There's no such concern in relation to the valuation of the business elements that are before you. The pandemic issues are clearly dealt with in the reports that you will have seen, and my client, it is fair to say my client would wish to make all sorts of points about the work that he needs to put in going forward to achieving the value that is set out for that business. But those are potentially points to be made to you at the final hearing. He doesn't say that the valuation report is wrong.
Understood.
In terms of the loan that my client received from his father in order to purchase his equity share, that does remain a live issue between these parties. It's a very clear part of my client's case that these are gross assets of 3.7 million. They are net assets of 2.7 million because he does need to discharge the liability to his father. It wasn't a gift. It is a loan. It is right to say it was made some years ago. It is also right to say that there has been no regular repayment of the funds loaned, but it is not right to say that it should be ignored. So it does appear that that is an issue between these parties that it is not going away. As a result of that, and I hear the points that you raise with Mr. Wagstaff about the intentions that he has or his client has in relation to calling evidence. I do accept that it is my client's case that this is a loan and not a gift, and he needs to prove that case, and he will ask his father. His father's written a letter that's been attached to the Form E disclosure, but it appears that is not good enough. And so he will ask his father to file a statement, and if the matter cannot be resolved, then so you will be asked to determine the issue of gift or loan. And in order to do that in my submission, so you will need to hear from my client's father in that regard. So live evidence will not only include Mr. and Mrs. Mitchell-Irwin, but it will also include Mr. Mitchell-Irwin Senior.
So from your perspective, again, just focusing on the issue of time estimate for a moment, from your perspective, likelihood 3 witnesses.
That's right, so yes.
Thank you.
In terms of division of the capital, yes, it's agreed that it's appropriate to divide it equally, and yes, my client will retain his business assets as part of that division. The retention of the pension is also likely because, unsurprisingly, it has a very obvious connection with the business in terms of it being the business premises that is part of the SIP. And so I would envisage that the parties would be able to agree how the balancing payments are met in the light of Mrs. Mitchell-Irwin retaining the home. But as Mr. Wagstaff says, if that isn't capable of agreement, then there may be some points that you are asked to decide about that. Sir, I think that deals with my client's points about the capital. So the only additional evidence will be my client's father. We won't need to call any of the experts. In terms of the income position, this is, as Mr. Wagstaff said, really where the dispute lies. If we could just turn to the second slide, please. The points between us are quantum and term, the age-old chestnuts that many of us have grappled with in all sorts of different hearings. The point that we may well need some expert evidence about is the earning capacity of the wife. I know Mr. Wagstaff said, well, it was raised at the hearing in court before the recorder that he doesn't propose serving any expert evidence. And I don't make that application before you today. I just raise it, so I don't know how you feel. Maybe you can assist us when I come to the end of my submissions, but whether you feel that you would be assisted, because the point that is made on Mrs. Mitchell-Irwin's behalf is she's not worked for around about 13 years. Previously, she worked in PR. My client's position is that this is a woman who is very bright. She has got a university degree. She has had a good career in PR prior to having children, and she has kept her skills. She does all sorts of different charity work. She has been working in the office of the children's school. And so she is not somebody that has only worked in the home. And so, sir, it's my client's view that there is more to this issue than simply saying, well, she's not worked and doesn't have an earning capacity. Sir,
I'm not going to start. I'm obviously very conscious of the time, Miss Heaton, so I think we'll need to probably wrap the PTR up relatively soon. But I'm not going to stand on ceremony in respect of the need for a Part 25 application in respect of earning capacity. But I'm not sure it's a matter for me as to whether or not I would be assisted by it. I think if it's a matter really for you, your client and your instructing solicitor as to whether or not you think in order to make out your case in relation to Mrs. Mitchell-Irwin's earning capacity, you would wish to adduce expert evidence. And of course, if you do, I would have to determine whether or not that evidence is necessary based on the competing authorities that Mr. Wagstaff has already adverted to. What I would be willing to do, Miss Heaton, although Mr. Wagstaff could say to me, well, we are here on the PTR today and really this is the opportunity to have made that application, and if that application hasn't been made, well, it's too late. I think in order to be fair to the parties, I'm going to give you, Miss Heaton, 7 days after today to decide that, and you can refer that to me by email if you make that application within 7 days, and I'll determine that on the papers. But as I say, I don't need a Part 25 application.
That's very helpful, sir. Thank you very much. The only other points to say in terms of wrapping up are, of course, the parties will need to file statements. Yeah. Their statements will need to set out their points about income need, and so it may be that it would be useful to have some analysis of bank accounts, bank statements, credit cards, etc. But that's of course a matter for the parties before you. So it's my view, sir, that a 3-day time estimate is ample to deal with this. We'll have 3 witnesses. And the issues will be the quantum of maintenance, then, sir, then it will be a matter of addressing the points about term, which of course are submissions points really rather than points of evidence. So I think that probably from my client's perspective wraps up the PTR issues.
Well, that's helpful, Ms. Heaton. I think we'll do the 3 days, but again, perhaps some may depend, of course, on what happens on your side in relation to earning capacity, as I've said, and perhaps you and Mr. Wagstaff and your respective solicitors can liaise as matters progress. And as Mr. Wagstaff has said, some of the other capital issues may fall into place. And obviously, if it's appropriate to reduce the time estimate, then again, just please send me a joint email and I can reduce the time estimate from 3 days to 2 days if that's considered appropriate.
Yes.
All right, shall we come out of character? Thank you both.
Yep.
Okay. So that is the PTR. That I hope I identified, or I was going to say identified the issues. There were too many identifieds in that sentence. That allowed us to try and identify the issues, and I hope flagged up some of the flexibilities of arbitration in terms of not requiring, for example, Part 25 applications and things can be more flexible, and also being flexible in things like time estimate. Laura, Chris, do you want to perhaps, if we go on to the third slide, perhaps highlight one or two of the other issues that can be perhaps canvassed at a PTR? Laura, do you want to go first?
Thanks. I'd just pick on that slide. I would just pick out the fourth point, because you don't always have to have this as a full hearing. There was an arbitration that I did in front of Nick Allen, and the early stages of that was a debate about whether in fact it would be an arbitration on the papers and that there would be no hearing at all. It would simply be a filing of evidence. It was about an appropriate lump sum payment in the context of an unmarried couple who had a child, so a different jurisdiction to that we're talking about today. But there was an issue there about whether you could simply do that on the papers. It became clear that that wasn't going to work, and that oral evidence would be needed. But the system has that flexibility within it that you don't have to go through a whole hearing, or you don't have to litigate every issue. Clearly, in what we're talking about, we've sorted out for the Mitchell Irwins, we've sorted out the division of capital, and the question is something different. So there's lots of ways of dealing with each individual case, bespoke to that case, to the parties, and with the views taken by the arbitrator. And arbitrators, in my experience, are willing to, as Nick did in that example, say, well, I will deal with that by email, or to have a short telephone hearing if something needs to be raised. The other thing I would say before I hand on to Chris is the points underneath that, venue and nomenclature. Again, there is flexibility. We are being formal, and that makes it much more akin to a court process. You may have clients who find that formality uncomfortable, not useful, difficult, and you can arbitrate on the basis of first names if that is what everybody wants. You can choose a venue that is suitable for all parties. And I think I did see a point in the chat earlier asking about whether it's very London centric. I am in London, so yes, there are arbitrations happening in London, but there is the possibility, particularly given you can do it on a video platform, of having counsel arbitrator parties in all sorts of different parts of the country, and it's, in my view, working really well. So those are just some of the things that can happen at PTR. Passing on to Chris, is there anything else that you would pick up?
I think I would make one umbrella point, which is, as Nick mentions, to emphasize the flexibility of the arbitration process, and that really underscores and emphasizes every single point that Laura and Nick have mentioned. Nick mentioned the flexibility, the ability to avoid formal applications. That has a cost implication that weighs against the cost of appointing an arbitrator as opposed to getting a judge who is free. Laura has mentioned the ability of the parties to arbitrate only to the extent that's necessary to resolve the issue. So you can reduce the time estimate as issues fall away because they're agreed. You can do that in court, of course. But of course, if you're dealing with an arbitration, it's much easier to increase a time estimate as well. We all know what the difficulty is if you are asking the court to make more time available to you. You want it this decade is the most common response. With an arbitrator, it's far easier, because, and as much as anything else, if arbitrator A can't increase his time estimate from 3 days to 5, arbitrator B may well be able to. So the parties have a much greater degree of control over the process and adapt the arbitration process to their needs and to the needs of the case. One of the advantages of that is that you can go from, at one end of the spectrum, you can deal with all sorts of issues that would arise in a court-based litigation scenario. You can deal with them quickly and easily in arbitration, even though that would be rather, as Ros made the point, rather cost heavy at the outset. And you can go right down to the bottom end of the scale, and where the parties in a middle to low money case have agreed everything bar the chattels, they can deal with the chattels themselves in front of a relatively junior arbitrator, and they can represent themselves, and they can do that in person, or they can do it by way of lists that an arbitrator makes a decision on. So you have got extreme flexibility right from the top end 9-figure cases right down to the bottom end where you're arguing about the clock that one party inherited from Grant Hermione or not. So I would emphasize the flexibility, and that is one of the key advantages of arbitration over a traditional court-based approach.
Chris, Laura, thank you. Just before we go back into roll to do the final hearing, the last item on our PTR list is use of the court process, and reversing one of the questions in the chat that says, can you switch to arbitration if you are already in court proceedings, to which the answer is yes, but we'll pick that up later. If you are in arbitration proceedings and you need the assistance of the court to make an injunction, a freezing injunction or similar, the court can make the same kind of ex parte injunctions it can make in court proceedings in support of arbitration. So you don't exit the court process entirely, even if you go into arbitration. And final point is simply picking up Chris and Laura's point about flexibility. When I'm an arbitrator, I often at the PTR will say to the parties, can everybody agree that the formal rules of evidence will not apply at the final arbitration hearing, meaning that you don't have to put every element of your case to the other party, and not putting every element of your case does not mean that it has been admitted, and that tends to mean things go a lot quicker and the cross-examination is a lot quicker, time estimate shorter, and therefore a cost saving. So we will go back into roll. We'll probably do the final hearing shorter than we did the PTR. So I'm going to guillotine Mr. Wagstaff and Ms. Heaton to bullet point submission. So I've got time to give a very short judgment, and we can still do 10-15 minutes Q&A. So concise, focused submissions, please, Ms. Heaton, Mr. Wagstaff. We are here on the final hearing. I understand the issues have narrowed significantly, Ms. Heaton. You're on mute, Ms. Heaton.
It's essential in every video hearing to have somebody stuck on mute. Thank you. Could we have the fourth slide, please? So you're right. The parties have, again, been working very hard to try and narrow the issues between them. We have agreed that Mrs. Mitchell-Irwin's income need should be taken at £120,000, so there's no need to determine any of the issues on the outgoing schedules. Her earning capacity should be taken at £20,000 per annum, and that's a net figure. And so the figure for spousal maintenance is going to be £100,000 per annum, taking one from the other. On top of that, my client will pay child maintenance, and he will also meet in full the school fees for both of the children, and the issues in terms of the extras on the bill have also been resolved. The issue between us is the term of maintenance. Mrs. Mitchell-Irwin still seeks a joint lives order. My client's position is that that should be a 10-year term until the completion of Eve's full-time education to the end of her university degree. So there are three broad points that I would make in support of my client's proposal that this should be resolved by way of a maintenance order, broadly a 10-year term. The first of those is, of course, the statute. It's where you've got to start, and you are reminded in that statute in section 25A of the fact that the court should make an order for periodical payments for a term that it would be, in the opinion of the court, sufficient for the party to adjust without undue hardship. And that really, sir, is the lodestone. It's that point about adjusting without undue hardship. And we say that that is exactly what Mrs. Mitchell-Irwin can do. Secondly, sir, you will need to consider the case law. Very often in a case like this, you will be urged not to crystal ball gaze, taking the phrase from the judgment in C&C. But sir, my reminder to you is that is a 1997 case, and that was, as we were reminded by Mr. Justice Charles in G&G, a case decided prior to the cases of McFarlane and Miller. And sir, I think there's a phrase that talks about C&C being a difficult case that has not made good law. Now, of course, I accept that it's a Court of Appeal authority, of course no judge is going to make a guess. But what you do need to do, sir, is make an examination of the facts of this case. And sir, in terms of the case law, I would also urge you to look at the decision of Mr. Justice Mostyn in NS and SS. He talks about the need where you have a finely balanced decision between a joint lives order and a term order to err on the side of an extendable term. The third area, sir, is obviously the facts of this case. We have here an asset pot, given that we have resolved the issue of the loan my client received from his father. It's now accepted that that was a loan, but it is also accepted that that does not require to be paid back immediately, and that will be paid back on retirement. The asset pot, therefore, is £2.7 million, and that gives each of these parties 1.35 million. And that is a pot that the wife will use for her housing. She is going to stay in the former matrimonial home, and that is worth £800,000. So the position that she is in at the moment is having a capital sum of over £500,000. She doesn't need to use that sum now because she is going to be in receipt of periodical payments for herself and for the children, and therefore that is a sum that she can invest. In terms of what happens in 10 years' time, we say, sir, that she will have invested that sum or should have invested that sum, and that will be income producing. She will also be able to make a decision about whether she stays in the former matrimonial home. At that point, both of the children will be much older, and it is a large and comfortable property. She may well choose at that point to downsize and to utilise some of the liquid capital from the sale of that property in order to put towards her income fund, her capital that she will then use to support and provide herself with an income. So on the facts of this case, so we say that this is a lady who can adjust to a term order without undue hardship. Even if she were to have, at the age of 51 in 10 years' time, £516,000, the Duxbury tables tell me that that will produce her an income of £30,000 per annum. That leaves her in her £800,000 house with £30,000 per annum, and her earning capacity, which we have agreed for the purposes of today at her age of 41 at £20,000. You'll have seen the points that we have made about her abilities, and my client is sure that as time passes and her experience increases, she'll be able to increase that. And also as her primary child caring responsibilities reduce, she will also be able to increase that. So even if she doesn't do that, there will be £50,000 per annum at 51 to enable her to meet her needs if she doesn't alter her housing position. You'll know, sir, from the case of Wygott that income is not a matrimonial asset to be shared. It is there to meet needs. That is going to be done whilst my client is working. And of course, you will also have seen from the documents that there haven't been any partners in my client's firm who have worked beyond the age of about 53, 54. I think the oldest was 55 when he retired. That is the plan. That has always been the plan. And so in all of the circumstances of the case, it would be right for you, sir, to make a term order to the end of Eve's full-time tertiary education. My client is not seeking a bar, and if he retires earlier or if something happens, then of course he will need to consider making applications to vary. But at that point in time, it would be right for Mrs. Mitchell-Irwin to have adjusted to her future position, relying on her her own earning capacity and the capital that she has from this marriage to support her going forwards. So those are my bullet point submissions on my client's case as to the term of the maintenance order. Unless I can assist you any further.
No, thank you, Ms. Heaton. Mr. Wagstaff, do you want to respond? It would be helpful if you were able to follow the same structure that Ms. Heaton did, dealing with statute, case law and facts.
Well, sir, there is a common ground between Ms. Heaton and myself in that the question is essentially for you. As she rightly says, one cannot justify a periodical payments order by reference to a sharing principle. One can justify it by reference to need. And so the simple question that faces you, sir, is this. In 10 years' time, when Evie has completed her full-time education, will Mrs. Mitchell-Irwin be able to adjust without undue hardship to independence? And the answer to that, sir, is I don't know. And crucially, you don't know that either. So she may need ongoing support at that stage at the level agreed now. Ms. Heaton fairly points out that armed with a Duxbury sum of £500,000, she'll be able to generate around £30,000 for herself. Together with an earning capacity, that will give her a global net income of about £50,000. That's going to be a reduction of £70,000 from what is anticipated at this stage. Can she adjust to the loss of more than half her income in 10 years' time? I don't know. And Miss Heaton doesn't know either, and neither does Mitchell-Irwin, and crucially, nor does Mrs. Mitchell-Irwin. She may need ongoing support, she may not. She may need a lesser extent or for a shorter period than a joint life term, she may not. But what is absolutely certain, sir, is that we can't make that decision here and now, and certainly not on this evidence. Miss Heaton puts the point in the following way in her written submissions. You'll recall that she said that in some ways that this is an issue of who bears the burden. She doesn't seek a 28(1)(a) bar very fairly, and so she says it would be open to the wife to apply to extend the term if she needs it. And she says that the difference between the husband's case and the wife's is that the wife says that the burden should be on the husband to reduce the term, for instance, if he retires at 53, 54 or something of that nature, whereas we say that the burden should be on the wife. The problem with Heaton's submission, sir, is this. The Court of Appeal, in the case of Fleming, said that once you make a term, you require very exceptional circumstances to extend that term. So it is easier on Court of Appeal authority to reduce the joint lives term than it is to extend a term order that is not backed by a bar. Now, it is a matter of, I understand entirely Miss Heaton's point that Mr. Justice Mostyn said that that is no longer good law in the case of SS and NS, but it is a matter of basic constitutional law that a first instance judge cannot override a decision of the Court of Appeal. And indeed, sir, this is not just any old decision of the Court of Appeal. The case of Fleming was cited not with complete approval by Baroness Hale in Miller and Macfarlane, but she did make the point that on the facts of Macfarlane itself, that the Court of Appeal were wrong to impose, as you'll recall, sir, in that case, a 5-year term, given that they had imposed such a strict threshold for extending the term. So although that is not precisely a ringing endorsement of the ratio of Fleming, it is certainly a long way short of being disapproval of it. It recognised the validity of Fleming and it paid regard to it. And so that is the law as approved by the House of Lords, as stated by the Court of Appeal. So Ms Heaton mentions the point of C&C and crystal ball gazing. So she might have gone on to mention that Lord Justice Ward's observation in that case, that the question for the court is not should she adjust, but can she adjust? And as I say, that takes you back to the simple answer that we don't know. The right answer in this case, sir, is for you to make a joint lives order. That does not mean that the husband will be compelled to pay any maintenance at all for the rest of his life, certainly not at the level that is currently agreed. What it does do is enable the court to make the right order in 10 years' time, which I accept entirely, might be a complete termination of the wife's maintenance obligation at that time. But we make that decision at that time, not now. Unless I can assist you further, sir, those are the wife's submissions.
No, thank you, Mr. Wagstaff. Thank you, Ms Heaton. We will come out of role play then. I'm conscious of the time. In an arbitration hearing, the usual procedure is that judgment is not given there and then. The usual procedure under the rules are that the award, as it's called, or determination, I think, in children proceedings, is given in writing within a reasonable period of time, which normally means 3 or 4 weeks. It is, of course, possible for judgment to be given if the parties want judgment there and then, and reasons are given unless the parties don't want reasons. So again, there is flexibility. To put Mr. Wagstaff and Ms Heaton out of their misery, on the facts of this case, my written award would have been to make a term order without a bar. I'm with Ms Heaton. I'm afraid I'm not with you, Mr. Wagstaff. Mr. Wagstaff is right to say the statute requires the court or the arbitrator to be able to form an opinion that the recipient of the periodical payment will be able to adjust without undue hardship by the end of the term. The combination of the wife's earnings now, the amount of free capital that she will have to invest, the ability to trade down her capital in 10 years' time, coupled with the likely retirement age of the husband, means that I think I would be able to form that opinion of an ability to adjust without undue hardship, and that would not be crystal ball gazing, and that would comply with the so-called statutory steer in the section 25A2 of the Matrimonial Causes Act to terminate the financial relationship between the parties as soon as is possible. So as Mr. Wagstaff starts drafting his appeal notice post Haley to overturn my award on the basis that it's wrong, I'm going to hand back to Ros, and we're a little bit later than we anticipated, but I hope we've still got a few minutes for some Q&A. Thank you, Ms Heaton. Thank you, Mr. Wagstaff. Ms Beaver.
Well, that brief was incredibly ambitious, but thank you so much to you for your spectacular and record-breaking interim decision and final judgment, less than an hour, and removing all of the mystery, which I think does shroud arbitration for those of us who haven't done one before. I've only done a couple. So it was absolutely brilliant and really authentic. We do have some questions, so very, very quickly. First of all, would you have agreed to allow an appeal? Certainly not, surely.
Well, I mean, anybody who asks the tribunal is basically saying, would you please give permission because you think you're wrong? So I can absolutely assure you, Ros, that I would refuse permission to appeal. And I'm pretty confident the High Court judge would chuck Mr. Wagstaff's appeal document out on the papers as having no real prospect of success. But I would say that, wouldn't I?
Yes, you would. So one of the questions that we have got is arbitration cheaper for clients?
I mean, you're in a better position to answer that than we are, Ros, but my view is yes, because the arbitrator may charge something between 2,000, 3,000, 5,000, 7,500, say for a one-day arbitration. But every solicitor on this call knows that one round of updating disclosure or another 3 months of the parties still being in the family home will generate correspondence that will far outweigh that cost. So I think there's a financial saving and an emotional saving to arbitration.
Yeah, the short answer to that, Ros, is you never know, because you either do a court-based process or you do an arbitration process, and whichever you do, you will never know quite how the other one would have panned out. So you can only answer that one with a little bit of judgment and experience. And as Nick rightly says, experience and judgment tells us that there is an upfront cost to arbitration, which is usually paid back several times over by the cost savings that are made down the line, not least in terms of things like, well, you have been told with a week's notice that the judge can't hear your case because he's got an urgent Children Act case to decide. So even though your brief fees have been incurred, you've been bumped off for another 4 months or something of that nature. That just doesn't happen in arbitration. Yeah,
certainly, particularly at the moment, I think that it's got to be a really powerful option. Yeah. And it is front loaded, but my experience has been the costs are not dissimilar. If in fact, on the cases I've dealt with, which are only a couple, they've been lower, I would say, than the traditional process. No waiting around at court, etc. So I think we've got time for one more question. Other questions can be answered subsequently. If you're new to this and don't really know the process, what's the best way to get up to speed?
Perhaps Laura wants to chip in on this, but my answer to that is the Resolution webpage is resolution.org has got very good material on all forms of non-court dispute resolution, including the benefits of arbitration, and the ifla.org website contains all material as well, guides for practitioners, guides for clients, and it's on the IFLA website where you can see the list of all trained arbitrators with an F next to their name if they're financial arbitrators, and a C next to their name if they're children qualified. Laura, I don't know if there's anything you wanted to add to that.
No, I was just going to say the IFLA website, it's not complicated. As Ros said, it's kind of shrouded in mystery, and you hear a lot of commercial disputes going to arbitration, etc. But it is like a court hearing, but it's more efficient. And there aren't complicated rules. There is an act. It's all set out on that IFLA website. Yeah, that's the place to go.
Ros, if you'll allow me just a sentence to pick up two of the very last questions in the -1 minute that we've got. Arbitration is not just for bigger cases, because you can choose a very junior arbitrator, solicitor or barrister, to arbitrate on the papers, and the fee will be very modest. So I don't think there's a threshold. What's lovely about arbitration is it's not one size fits all. And the answer about can you get cost orders in arbitration is yes, exactly the same cost rules apply in financial remedy proceedings, save that if you want to choose a different version of the cost rules, including the ability to make the equivalent of Part 36 offers under the CPR, offers that are without prejudice savings to costs, call-to-bank offers, you can. So again, finishing off where we started, there is that greater flexibility in arbitration.
So in summary, for me, and I'm sure for many of us on this call, that has been a brilliant overview of the process, and so authentic in my view. It was absolutely fabulous. And really it demonstrates that as a family law community, and for others who are on the call who are not practitioners, it is a really credible way forward, and one which is not dissimilar to the court process, but has lots of flexibility. For my part, I think the rules, it's only the same as getting familiar with any rules, like when you change anything. And for the lay client, of course, they're new to absolutely everything when they're coming into the process. So it's us as practitioners, I think, that need to change our mindset as opposed to our clients. Thank you so much to our panel. You've been brilliant. And thanks to everyone else for joining us. If people do have further questions, I know that Nick, Chris and Laura would be willing to answer them. So please do send them across. And if you've got further questions, we can try and field those for you. Our details will be on screen, and we would really appreciate it if people could give feedback. We like doing these live events. We love engaging with our colleagues in at the bar and seeing them in action. It's been fantastic. So thank you very much.
Pleasure. Thank you for inviting us.
Thanks very much.